But I mean, I have a,
There's no light or any indication of how.
Whether it's on or not. So I think if it's down, it's on. If it's up.
It says which one's which. You just have to assume it's working.
So on is when it's off.
Yeah, so you can feel it. Push it all the way down, it kind of stays down. Pull it up, it kind of pulls up.
yeah.
So if it's down, it's on.
Oh,
So it's on right now.
okay.
Now it's on.
All rise. Oh yay, oh yay, oh yay. The Honorable Court of Criminal Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court. Please be seated.
Good morning and welcome to this June calling of the Tennessee Court of Criminal Appeals docket here in West Tennessee in Jackson. We're delighted to see you today and welcome everyone. We're proceeding under new protocols, trying to stay busy and working as we have throughout the COVID pandemic. And we have taken steps as a court to provide the public, interested parties, the media, unprecedented access to our proceedings and to our court. You can come and be with us and see us in person. I was a little bit offended the other day when I saw a news article that said we're now hearing cases online. No, we're hearing them in a courtroom just like we always have, but we are broadcasting them on live for the public and those that are interested to see. You can also call in, and there's a telephone number if you wish to hear what we're doing and may not have access to a telephone or computer. So there's three ways you can come. You can watch live on YouTube, or you can call in and listen. And we appreciate the help of all the staff, our staffs, the clerk staffs, the AOC staffs. The attorneys have been marvelous in their cooperation to try to help us set standards that would be safe for them and the general public that could attend. For that, we are grateful. I'm honored today to sit with my colleagues that I'd like to introduce to you that will be your panels today. To my left and your right from Memphis, Tennessee, Ross Dyer. To my right and your left from Memphis, Tennessee, Judge Camille McMullen. I'm John Everett Williams from Carroll County, Huntington, Tennessee, just up the road. Each side is awarded 20 minutes per argument. If you're the appellant and you wish to reserve any time, please do so upon introducing us. Pursuant to our new protocols, we are allowing and suggesting that you stay at your table and do not attend the podium. You may stand or you may be seated, depending upon what your style and preference is. We have none. You may wear your mask or you can remove your mask, either way that you are comfortable. I hope you're not having any trouble hearing me with mine. This is the first time I've ever spoken in public that I recall with a mask on. And I hope you're not having any trouble. If you do, please tell me and I will remove it when I have questions. With that, Mr. Clerk, would you please call the first case?
State of Tennessee versus Joseph Moran.
I'd like to reserve 5 minutes for rebuttal.
Yes, ma'am, and I'll try my best to help you keep up with that, okay? You may proceed.
May it please the Court. My name is Jessica Wiseman, and I'm here today on behalf of the appellant Joseph Moran. We are respectfully requesting today that this court reverse the trial court's decision and remand for a new trial for two reasons. First, we would submit that the trial court erred in admitting at trial a confession that was made by Mr. Moran to the crime of sexual battery while he was sitting handcuffed in the backseat of a police car, but before he was ready, the warning took part by Miranda v. Arizona. And secondly, we would submit that the state did not bear its burden of proof in proving beyond a reasonable doubt that the admission of this confession, or this supposed confession, did not contribute to the verdict obtained. The trial court held in this case that due to the inherently dangerous nature of domestic violence calls, officers were permitted to handcuff Mr. Moran at his doorstep, escort him to the back of the police car, and then interrogate him.
That wasn't the only thing. It seems like in your brief, as well as in your statements this morning, counsel, is that you're focusing on the nature of the call. The trial court's order in this case was extensive. You're not saying that that was the only thing that it based its decision on.
No, Your Honor, I'm not. The trial court order was extensive, and it went through all of the different 8 factors, I think, that it was required to look at under
Anderson, yes.
Anderson.
Mhm.
I'm sorry. Ms. Wiseman, would you
Sure, sorry. So the trial court did go through all of those factors, and of course, we would also submit that the trial court's analysis was erroneous.
Well, the trial court requested briefing from both parties, and I didn't find briefing from either party in the record.
Your Honor, it's my understanding that there was briefing from the defendant's counsel, but not from the state. There was actually, I think, pre-motion briefing, pre-hearing briefing submitted by defendant's counsel, but not by the state, but then both parties submitted post-hearing briefing.
And that's in the record?
It's my understanding that it should be, Your Honor.
Okay.
And if it's not, we would respectfully request to supplement the record if Your Honor would find it appropriate, but if not, I understand. But so we would also submit, going to what Your Honor was saying, that the state cannot meet its burden in proving, it cannot and did not meet its burden in proving by a preponderance of the evidence that Mr. Moran gave his confession pursuant to a knowing, intelligent, and voluntary waiver of his rights. Mr. Moran and Ms. Frisbee, the alleged victim in this case, lived together for many, many years, and they were in a long-term relationship. On the date of the incident, they took a shower together voluntarily. They got dressed, and Ms. Frisbee informed Mr. Moran that she cheated on him with another man on a cruise that she had just gone on with her mother, Sheila Hatkey. Mr. Moran and Ms. Frisbee got into a verbal altercation, and when they got into this altercation, Ms. Hatkey was actually on the phone with Ms. Frisbee, and at some point the phone was hung up during the verbal altercation. Ms. Hatkey then called Ms. Frisbee's brother-in-law, Zachary Seals, and asked him to go over to the house to check on her. When Mr. Seals arrived, he observed Ms. Frisbee in the doorway, fully clothed and packing a bag. Ms. Frisbee and Mr. Seals then went outside and discussed it for a while. I think that they consulted her sister, and then they decided to call the police. When the police arrived, Mr. Moran was inside the house, and Ms. Frisbee was sitting outside with Mr. Seals. We would submit that there was a factual error made by the trial court on volume 3, pages 55 through 56 and 74 of the record. The trial court erroneously stated in its order that Mr. Moran and Ms. Frisbee were sitting outside together. We would submit that they were not.
But as I read the trial court's order, he also in there talks about and says they knocked on the door and the defendant stepped outside and says this was their first interaction with him was once he was outside. I mean, I understand your point, but is there really going to be a huge difference in the analysis as to whether he was outside when they first showed up or whether they knocked on the door and then he came outside to talk to them? I mean, the
No.
analysis,
No, Your
is really from the moment they interact with him going forward. It's not necessarily where he was standing when the officers showed up, is it?
No, Your Honor. It's, I think that the important thing there is the fact that the parties were separated. They had already self-separated, and there was no urgency in the situation that would have merited some sort of investigatory questioning at that point.
But the officers don't really know anything yet, other than there's been a domestic call.
From what I'm understanding, I'm sorry, go ahead, Judge.
Well, there's been a domestic call and both parties are still there, whether one's inside or whether one's sitting on the porch. That's really all the officers know. I mean, do they not have a duty to investigate the domestic call?
Yes, Your Honor. Well, they did have a duty. I mean, they spoke with Miss Frisbee before they went and knocked on the door. And what they did is, without obtaining any more evidence from Mr. Moran, they handcuffed him immediately at his doorstep. So
you're saying he should have been Mirandized at that point?
yes, Your Honor.
But I mean, I think
What were they advising him of his rights for?
Because they were taking him into the back seat of the car to interrogate him. At that
For
point,
what? I'm sorry, for what?
well, the thing is between the time of the incident and the time of trial, the officers couldn't remember exactly what they asked him.
I got the impression that was the problem in this case. They didn't write it down in the incident report, and they were recalling from memory, solely from memory.
Right.
So I get that. I get that you had some credibility issues there, but from the moment they arrive on that scene, your position is that Miranda applied upon them coming out of the door?
Miranda applied upon them handcuffing Mr. Moran and escorting him to the back of the police
I
car.
mean, I think the law is pretty clear. The U.S. Supreme Court has said handcuffing does not mean that you're necessarily in a position where Miranda is required. I mean, you can under a Terry stop, I can handcuff you for the officer's safety, for safety of the public, for any amount of reasons, and I haven't placed you in custody at that point as to where I've triggered Miranda. So simply because the defendant was handcuffed in this situation, and I think that's what the trial court seemed to be getting to, was, again, this is a domestic situation, and it may have been calm at that very moment. I understand your point there, but these are usually highly charged, highly emotional situations in which the officers really don't know what they're walking into. And so for their safety, for the defendant's safety, for the victim's safety, he was handcuffed while they asked him a question. I agree with Judge McMullen and your point that there's a problem with the fact they didn't write down everything. Unfortunately, based on what we have, it's hard for me to call this a true interrogation when it seems like it was a pretty open-ended question of, hey man, what happened? So, I mean, just because, I guess that's what I want you to address, is simply because he's handcuffed doesn't mean he's in custody to trigger Miranda, does it?
Well, no, but so first of all, I would cite back, it's not just the fact that he was handcuffed, but it's the fact that he was handcuffed in the backseat of the police car. I cited to it in my brief multiple times, State v. Walton. The Tennessee Supreme Court has already held that an individual who's handcuffed in the backseat of a police car is in custody for purposes of Miranda. And I would note that
that was before the U.S. Supreme Court said that Miranda doesn't apply to Terry-type investigatory stops, right?
Right, and we would submit that this was not a Terry-type investigatory stop.
Well, the officers in this case were in fact responding to a domestic call, right?
That's correct.
And they were in their preliminary stages of determining what was going on, right?
I don't know that, I would dispute that, but I don't think that any of the facts of this case indicated that a Terry-type stop was necessary. Mr. Moran readily identified himself to the officers. He voluntarily came to the front door. They didn't have any other suspects in this case. I think that's very important. Mr. Moran was the only suspect. Nobody was in immediate danger. They didn't think that, they didn't have any inkling that there might have been firearms anywhere. So I think that those facts would distinguish it for that purpose.
Is Judge Ward trying to create an exception to the standard rules of custody and interrogation by what happens in a domestic relations call?
I mean, Your Honor, that's the way that I read his order, but
I mean, if the call had been that shots had been fired at house number 393 and the police arrived to investigate shots, would he be considered being placed in custody and is a Terry stop? And
well, Your Honor, I think that in that particular scenario, there's an exigency or an urgency there that was not present in this case. I mean, it was a domestic violence case, and I guess that you could argue that they're inherently dangerous. I think that's what the judge put in his order, but you could argue that about any number of crimes.
Well, he didn't just put it in his order. I mean, he did at least like cite to data and statistics showing that domestic violence has a higher rate of exigency, I guess, and emotion and danger attached to it. I mean, it's not like he just made it up out of thin air.
Yes, Your Honor, but I guess my point is that it's a legal standard that just hasn't existed in Tennessee law to this point.
Well, let's get to that point. Let's talk about what I saw in Judge Ward's order. First, the issue of, I guess, not standing, but he was asking who had the burden of proof to establish custody, whether it was on you all as the defendant or the state. Can you speak to that?
Yes, we would submit that the judge erred in that respect and that it was the state's burden to prove by a preponderance of the evidence that Mr. Moran gave his confession pursuant to a knowing, intelligent, and voluntary waiver of his Miranda rights.
You don't distinguish between the two issues?
Between Terry and...
No, between the burden of proof to establish that your client was in custody and the knowing and voluntary nature of his confession.
Well, Your Honor, excuse me, sorry.
You look back at my notes too, because I thought that's what.
Yeah, I think the distinction the trial court drew, and I think this is where Judge McMillan's question is coming from, is he sees as a two-pronged standard. First, the defendant has to show whether or not he was in custody and whether or not Miranda was triggered. Then once the defendant can prove he was in custody, the burden then shifts to the state to prove Miranda was given and the confession was knowing and voluntary at that point. That was what the trial court's drawing two different distinctions. You first have to show you're in custody, because if you can't prove you're in custody, then Miranda's not triggered and all these other things are not triggered. But if you can show you're in custody, then the burden shifts to the state as far as the knowing and voluntariness of the confession. And as I read Judge Ward's order, and I think this is where you're going, Tennessee has not spoken on this issue. Our Supreme Court has not spoken on this issue. So I guess the question to you is, where does the defense fall on? Is there a two-pronged burden of proof? Is it really just one burden of proof that's squarely with the state? Because that's where the court drew its distinction. Go ahead.
And that's really what I was asking you initially, counsel. Judge Ward is trying to, we keep saying Judge Ward, the trial court, I don't want to single him out. The trial court in this case was trying to get some feedback from counsel here, because this is an issue that Tennessee has not addressed. So that's why I was looking in the record to see what your position was, because it's not in your brief. The cases that you cite in your brief do not address the burden of proof when it comes to custody, who has to establish custody. So you cite several cases from other jurisdictions that speak to factors that demonstrate custody, but they don't speak to whose burden it is to establish that. Does that make sense what I'm saying?
It does, Your Honor. And, I apologize that I didn't catch on to that in reading Judge Ward's order, but he was actually my crim pro professor, so I feel like I failed him somehow. But, the defendant would assert, and we would argue that, and I don't know that there's a question. I mean, obviously, we're arguing here today that there is a question. I mean, the point of being here today is that there is a question, but Mr. Moran was handcuffed and in the backseat of a police car, and I don't know, to me, it seems very clear cut, and we would assert that because of that, I mean, even if it were a two-pronged standard, that
Well, he's saying you failed to carry your burden. He cited other cases from other jurisdictions and said that the defense failed in carrying their burden of establishing custody. He is going with the majority view that the burden is on the defendant to establish that. So that's really what we're asking you today.
Right. And I think that the state also noted in a footnote in their brief that you're reviewing the judge's application of the facts to the law de novo. So, in a way, it's almost your decision.
Right. But
and
you're
which
the
I understand
advocate.
why you want
You're the
an opinion.
advocate. You're supposed to be telling us what
Right.
your position is. Yes.
We're getting into your rebuttal time right now, and we've asked several questions. I can extend a little time to you, but are you through with your argument?
Yes, Your Honor, I'm through for right
If
now.
I can just ask
Sure.
you one question.
Mhm.
So assuming we find the confession stays in and we get to the sufficiency of the evidence argument, does your sufficiency argument fail if the confession is in? Is your sufficiency argument hinge only upon if the confession's out, there's not enough here, but once the confession comes in, there's probably enough here?
Well,
Basically, I'm not saying you have to concede that there's sufficient evidence. I'm just kind of asking, is the confession the linchpin to your sufficiency argument?
Your Honor, I mean, without conceding anything, I think that the confession was, or the alleged confession, I wouldn't deny that it was a very important part of the jury's verdict. And you can see that in the fact that they chose not to convict him of rape and kidnapping, but they did convict him of what the supposed confession spoke to. So,
Thank you. Thank you, Judge.
Thank you. We'll hear from the state now. Thank you.
May it please the court, Catherine Decker for the state of Tennessee, and am I heard well?
yes.
Okay. This court should affirm the trial court's judgments for two reasons. The trial court correctly denied the defendant's motion to suppress, and if the trial court did err, then any error was harmless beyond a reasonable doubt. So let me turn first to the question of the burden of proof. And as you can tell from my brief, I gave it short shrift. And just as defense counsel did, I jumped right to the Anderson factors. So in preparation for my oral argument, though, I did extensive research, and I refer you back to the judge's several cases provided in his order denying the motion to suppress on page 25 of the technical record. The analysis is this: before the Miranda rights are triggered, it is the defense's burden to prove that he's even entitled to the Miranda rights. He has to prove two things. One, that he was in custody. And two, and this goes to Judge Dyer's question, I believe, whether he was, there was a police interrogation. So before he's in custody and before there's a police interrogation, Miranda doesn't even come into play. So the defendant has that initial burden. Once the defendant meets that burden, then, and this is where the defense counsel has keyed in on, then it's the state's burden to prove beyond or by preponderance of the evidence.
Let me stop you, counsel.
Yes.
Was there, the defense counsel was Art Quinn in this case. Was there a defense memorandum? Judge Ward asked for that from the parties below. Is that in the record?
I have the record here, and I don't see it in the table of contents.
I did not know if you all had one, but Okay,
I don't see it in the table of contents. It's in the technical record.
thank you.
So the majority of states that have considered this issue, and that's not the majority of the 52 states, it's just the majority of states that have considered this issue have found that it is the defendant's initial burden to prove custody and interrogation, followed by the state's burden to prove beyond, by a preponderance of the evidence that the confession was voluntary. And those states include Texas, Maryland, Vermont, New York, Massachusetts, Connecticut, Virginia. And those are the cases that I've found. And then the judge has several cases too cited in his brief. A good case, and I'll just speak into the record that he doesn't have here, is State v. Thomas out of Maryland, because it has a long cite of these cases.
You have a site?
And I'll give you the cite. It is 33 A 3rd 494. And this issue is discussed on pages 505 to 506.
So I'm
Now,
assuming it's the state's position that we adopt the majority view?
I think this would be a really good opportunity to do that. The state of Tennessee has not spoken into this, and it just makes logical legal sense to adopt this analysis. I will say, and as the trial judge acknowledged as well, you've got Maine and Wisconsin that hold that the state has the burden of proving custody by a preponderance of the evidence. So it's not, uniform, but the vast majority of the cases, states who have considered this place the initial burden on the defendant.
We're in a state where not too many years ago, you could be riding a bicycle and the police officers could turn on your blue lights and you would be considered legally in custody. Right?
Well,
Do you remember that?
no.
You don't remember that blue lights indicated custody in Tennessee for years and years and years?
For all of those years, I was practicing law in the state of Texas.
Okay.
But
Well, I assure you it did happen. And now you're telling me that if I show a man is handcuffed in the back of a patrol car, has no idea what he's being handcuffed for, does not know what he's being, what charges he could possibly face, or what reasoning the police is holding him and he's not free to go, that he's got to prove what else to be proved in custody.
well, and
What
that's
else would he have to prove?
Well, and that's where you have the Anderson factors, because it is not, you just don't look as was he in handcuffed in the back of a car. No, you don't look at just those two facts. You look at all of the Anderson factors. And
What Anderson factors do you say were favorable for the state?
well, I think that the time and location of the questioning, it's the middle of the day. And yes, he was in the backseat of a police car, but the doors are open. It is in a familiar place right outside of his apartment or condominium.
But
And-
he has been taken away from his home and taken into a private setting, correct?
That's true.
Are the officers required under law now to try to determine who was the first aggressor?
I don't know if they're required under law. And I'm not sure that no matter if they are or not, you still look at all of each single Anderson factor, and then and then you weigh them against each other.
Let's say they were to determine who was there used to be a requirement that they try to determine who was the initial aggressor. So that would give them an incentive to be interrogating an individual that they have in their control. Well, I won't use custody, but in their control to find out whether or not they were the first aggressor.
Sure, the interrogation itself, though, does not necessarily trigger Miranda, because of course that's what you'd want the officer to do when they arrived on the scene, to ask questions to determine what's happening. The question is, going through the Anderson factors, would a reasonable person have thought that at the time he's being interrogated, that he was under formal arrest?
How can we determine what a reasonable person would have thought as far as the interrogation is concerned, when your officers don't even write down what took place in the interrogation? How can we put that, one, how can we put that burden on the defendant? I mean, it's not his police report. It's not his interrogation. It's theirs, if it was an interrogation. How can we put that burden on the defendant? And then two, how can we make that determination?
Well,
If there's nothing there, I don't have a memory, but they sure do remember some things very specifically.
the Anderson factors we have enough information to go through the Anderson factors. What was the particular questions asked in the police car, they go to whether there was an interrogation, but that's a separate question as to from
Right,
whether
and
there's custody.
I'm sorry, let me make that a little more clear. If the state's advocating the two-prong burden of proof, that the defendant has to prove custody and then the state has to prove voluntariness. And you said in your opening remarks that in order to prove custody, one of the things you have to prove, there's two things, one of which is there an interrogation that took place? How can the defendant meet its burden if the state doesn't preserve the evidence, for lack of a better way of saying it?
I guess and I would piggyback on what Judge Dyer is saying. I would like your position on operationalizing this burden of proof. Are we asking, I guess, our defense bar to be prepared to put in the same sense as a motion to suppress or something like that, to put the defendant on the stand, give his version of, or his perspective of what happened when he was, I guess, temporarily detained, for lack of a better word? Is that what the state's getting at? Because that's the impression that I get. I know in this case, these officers totally messed up. We got a rookie officer who didn't memorialize what happened, joined with a senior officer sitting in the car who overheard the rookie officer's exchange with the defendant, correct?
Correct.
Okay. So,
Well, correct as to the facts. I'm not sure I would.
okay.
Okay,
So yes, we're trying to
characterization.
get to operationalizing this rule. I think that's what everybody's comments are getting to. How do you do that? And then how does the defense, other than, I guess, cross-examining the lack of proof, establish this objective standard?
Well, if you just look through the Anderson factors, the time and location of the questioning, I think that there's a variety of sources of evidence that could come in on that, the duration and character of the questioning.
But we don't know the character of the question.
That's true in this case. The officer's tone of voice and demeanor would be evidence that the officers could provide. The method of transportation to the place of questioning, I think that's just a factual issue that could come through the officers. The number of officers present, again, could come through the officers. Any limitation of movement or other form of restraint, again, would come through the officers.
So let's take a hypothetical or make up some facts for this case. The officer testified in the trial court found that the officer's demeanor was calm and this, that, and the other. Okay, let's take that as fact. But since we have no idea what questions were asked, even if the officer is calm, if he's calmly saying, look, we know you beat this woman, we know you did this, we know you did this, we know you need to confess, we don't know that.
That's true.
And which would go to the voluntariness of the confession. It would go to whether he felt he was free to leave. It would go to custody. It would go to all those things. And you're saying part of that's the defendant's burden. How are we supposed to deal with that?
Well, if you, in claims, for example, involving coercion, it would not be unusual for the defendant to testify at the motion to suppress hearing. So it's not overly burdensome or unusual for a defendant to have said, of course it didn't happen in this case, but to say, well, I know you can't see it you can't hear it, say, in an audio of my confession, but he was holding me this way, or you can't see it, but I had been deprived of food and water that evidence comes in through a defendant. So I think operationally it can work.
I think that's what you're asking judgment on.
Yeah. If you don't I'd like to rest on my brief for my specific analysis of the Anderson factors, and I'd like to turn to the harm analysis. Beyond a reasonable doubt, the defendant's statements that came in through Officer Lynn to the jury did not contribute to the verdict because the defendant's guilt was cemented. by the victim's detailed testimony, the corroborating evidence of the 911 call, multiple witnesses, and physical evidence.
Isn't there at least a provision under the law that we really do not wish to convict people by their own statements? The law protects them. They give them Miranda protection. We have built a system of over 200 years of jurisprudence that we would prefer proof instead of out of their own mouths.
We have that proof here that the harm analysis takes into consideration that overarching proposition because it requires the state to prove beyond a reasonable doubt that the error did not contribute to the verdict. And when you have the type of evidence that we have in this case.
And what did you have?
Well, first, we have her detailed testimony about the assault,
Okay.
where it all makes sense because she provides a clear motive for the assault. And that is that she's been gone a week from the cruise. She comes back, they take a shower together. Her boyfriend reasonably thinks they're going to have sex. She says, no, not really. I've slept with another man. And that he reasonably becomes outraged. And there you have a clear
Did
motive.
you say he reasonably became outraged?
I don't think he, it's reasonable that he became outraged, and I'm not saying it's reasonable what he did with his outrage.
So we don't have a motive, or we do?
I think we have a motive that
But it
everyone,
was a reasonable motive.
it is a reasonable motive to become outraged. And it certainly, certainly something that lends credibility for what she says happened after she
Okay,
told him
so
she had
we've got
cheated
a
on
he
him.
says, she says proposition right now.
We don't,
Do we have any physical evidence?
but we have, it's more than a he says, she said, he said situation, because within 15, first of all, she provides that motive. Second of all, she describes very unusual and particularized details, so that if she were making up an assault, these are not the type of details that she would provide. So he takes her clothes off, pulls her down into the, from the second floor to the first floor, brings her outside, and invites the neighbors to come and look at this whore and who else would like to sleep with her, all again relating back to
So what corroborates her story then?
Okay. What corroborates her story is first, within 15 minutes of the assault, she calls 911. The 911 tape I couldn't describe in detail in my brief because it hadn't been included originally with the appellate record. The appellate record, I have since had it supplemented with the 911 tape. But so it's within 15 minutes. Her voice is very shaken, clearly.
So that's not in the record?
It's currently in the record. I had the record supplemented.
It's been supplemented.
Yes. It's very clear that she's had something very distressing that's happened to her. And this is what she told the operator. He grabbed me. He kept talking me down over and over. He threw me and he took me into the street naked and told everyone to look at me, and then he raped me. So there's the 911 call within 15 minutes of the assault. You also have Officer Lynn showing up at the scene shortly thereafter, and she tells him the same unusual type details. They got home from vacation. He wanted to have sex. She told him she cheated on him. He dragged her downstairs and outside, brought her up and threw her on the bed. And then, of course, the unusual detail that his penis was not hard enough to penetrate her, so he rubbed it on her vagina. So then at the Rape Crisis Center, she reports similar, he held her down, forced digital, and attempted vaginal penetration.
Well, I believe her, okay? So if I believe her, that's all I need to do, right? I mean, if I believe her story, and I do, that's all I've got to do, right?
Well,
when this is sufficient evidence to find him guilty.
I think that she's provided enough evidence of each element of the offense. And I think the fact that her testimony is so detailed and particularized with these unusual events of the offense, and that she repeats it to the 911 operator and to Officer Lynn, the same unusual type events, cements the fact
But
that the jury would have found her credible. I'm sorry.
Was there anybody that saw her naked in the streets?
No, but
Was there any like I said, was there any physical evidence that was introduced? Any photographs of the injuries or anything of that nature?
Well, there was that, but let me just mention one other, somehow I got a feedback.
louder,
but Yeah.
that's okay.
But let me just mention two other witnesses, though, and that is that we have corroborating evidence at the beginning of the assault as well, because at the beginning of the assault, the victim was on the phone with her mother. She was telling her mother what had just happened, and at that point, the defendant came up the stairs, and this is what the mother testified. She heard the defendant scream at the victim, followed by some scuffling and some thuds. So you have the mother corroborating the beginning of the assault. And then on the bookend of that, you have the brother-in-law coming and interrupting the assault. And he saw Miss Frisbee very frantic and obviously in distress. Again, clear signs that something quite alarming has happened. As for physical evidence, we have photographs taken the day after the assault of bruises on her arm and flank. There could be, the defense has suggested other explanations for those bruises, but nevertheless, we have photographs of the bruises, and they line up with how he had manhandled her.
Well, if I've read correct, and I have not read the transcript, but in reading the briefs, as far as the bruising is concerned, I mean, didn't the doctor testify that they could be older than a day or two? Is that not correct? I mean, so how does that really corroborate her story? They're there, but how does that really corroborate her story if there's a question as to when the bruising actually occurred?
Well,
Unless I misread the briefs.
no, you did not misread the briefs. The doctors never know exactly how or when bruises arose, but when she said she was manhandled and she has bruises where she was manhandled. And so it's not dispositive, but it certainly is corroborating evidence. And then you have this DNA evidence where his DNA is found on the underwear that she said that she had put on right after the assault.
Which also, again, the doctor had to admit he didn't know when that was. It could have been there 3 days before the assault, or it could have been there the day of the assault, right?
It's not dispositive, it's corroborating. And on the other hand, you have the evidence that came in about what he said. Very limited evidence. You have Officer Lynn testifying that the defendants and the victim stories were similar. Well, that's just so vague that it doesn't contribute to the verdict. And you have Officer Lynn saying the defendant could not get his penis hard enough, so he rubbed it on her vagina. He's not confessing to coercion. And in fact, that was one of his defense theories in the opening and closing statements was there was no conversion. And his idea was that she had some kind of safe word. Apparently they had rough sex, and she had a safe word that she would use if she wanted him to stop. And so his theory is, well, this really wasn't coerced. It was really just rough sex, and it wasn't even so rough, or else she would have used the safe word. But of course, she knew she couldn't use the safe word because he was assaulting her, and she knew that it wasn't part of their routine, and he wouldn't stop.
Can I ask if you get the sense that Judge Ward was making an exception to, in this case, because of it being a domestic relations type case?
I know that he discusses that in his order. I don't think he's trying to make a legal exception. He goes through all the Anderson factors. So
he's strictly relying on Anderson and found it favorable for the state and not for the defendant.
Absolutely. I think based on his...
So if this was a murder case, as I gave, or a shooting, and they came and they put him in the car and did the same thing, would it be treated different? I mean...
It would be the same Anderson factors. The same Anderson factors.
Okay.
I briefly would like to address some of the mischaracterizations that were in the reply brief. And
very briefly.
Okay, very briefly. The defendant says that the most probative damaging evidence was his confession. And of course, as I've stated, that is just simply not true. It is all of the other evidence that cemented his verdict, and his statements were just very limited and vague. excuse me, in the reply brief, the assertion is made that Ms. Frisbee's story has changed. Ms. Frisbee's story has never changed. From the time she told the police, the 911 operator, the rape crisis center, her story never changed. Whether she provided more limited details to the rape crisis center, that's one thing, but her story never changed. There was also not a stark contrast between what she said occurred when her brother-in-law came to the door and what her brother-in-law said. They didn't remember whether she was already downstairs or not. It is a trivial discrepancy having absolutely nothing to do with the assault. She also did not have to consult her family as to whether there was an assault. When the defendant was in the back of the police car and asked to speak with her, she consulted her family as to whether that might be a good idea. But she did not have to consult her family about whether there was an assault. She did not want to press or get a SANE exam when she went to the rape crisis center the first night. She went back and did the SANE exam. That is absolutely common in domestic assault cases, especially when their lives are so intertwined. She had lived with him. She was paying rent to him. This hesitancy to press charges.
Is the state asking us to make major changes in the prior law that has existed in the state of Tennessee in this case, or are they pretty much just saying Anderson is it?
It's the Anderson factors, and under those factors, which I think the judge correctly analyzed, and some way for custody, some way against, and you just bounce them all up. And
Okay.
so it's the Anderson factors.
I need you to be clear on answering Judge Williams, because you answered my question differently earlier. My question was specifically in regard to whether the state's position was for us to adopt the majority view in terms of whose burden of proof it was to establish custody. And Judge Williams has spent a significant amount of time questioning you on that. So I want you to be careful in how you answer that.
I view them as two separate issues.
Okay, all right.
The first is who has the burden of proof, and then using the Anderson factors, has the party that has the burden of proof met that burden?
All right.
Okay, so which one are you asking us to change? Or are you?
I think I misunderstood your earlier question. As for the analysis of whether,
I'm giving you a chance to answer.
I think this would be a really good opportunity for this court to speak into the law of Tennessee and adopt the majority view that the defendant has the initial burden of proving custody and interrogation.
Do you have a Tennessee Supreme Court case on point?
The Tennessee, as far as my research and apparently the judges, has not considered who has the burden of proof on the question of custody. And then after the defendant meets that initial burden, and so that Miranda comes into play, then the Anderson factors are used to determine whether the defendant has met that burden, met that burden.
I want to get the clarification again. So a second ago, you said the Anderson factors are used to prove, to establish both burdens. Now you're saying the Anderson factors don't kick in until the defendant establishes custody. When do we use the Anderson factor? If we're going to go with what Judge Ward and the trial court and the majority of other courts have said, that there's two burdens, when do the Anderson factors that the Supreme Court has given us, when do we use those?
The defendant has the initial burden of proving he's in custody and there was interrogation. Then on appeal, the Anderson factors are reviewed to determine whether the defendant met that burden of proving he was in custody. And that's, I think, what the trial judge did as well.
Okay.
And then I know I'm taking time, and with permission, Judge Williams. Do you see any potential abuses? And I think Judge Williams was hitting on this earlier with adopting the first prong of your analysis, the majority view of requiring the defendant to establish custody. Do you see abuses, any abuses, potential abuses? I mean, this is a difficult question But I'm just sitting here thinking about responding to home burglaries and the homeowner being put in the car in handcuffs because, just because officers are afraid, obviously, when they go into situations like that. But can you speak to that, or speak to the state's position on potential abuses in adopting the majority view?
I haven't thought about the practicalities of it, and I think that that would be easily fleshed out by, and I could, if the court would like me to submit a post argument brief, I'd be happy to, but I think if to see what type of evidence was introduced in all of those cases that Judge Ward that cites, then the court might be put at ease as to how, as a practical matter, that burden's carried out in the other states that adopt that analysis.
I don't know if the other panel members would, but I think that's what Judge Ward was looking for when he was asking for briefing on this issue. I was looking for the briefing. I know Judge Ward's order is it was very detailed and comprehensive, but I couldn't tell what your positions were on appeal in terms of that issue. Both of you acknowledged that you didn't immediately hone in on what the trial court was really getting at in this case.
Before I allow any rebuttal, you have offered additional briefing on what issue?
As a practical matter, at the motion to suppress hearing, how, if I'm understanding you correctly, how this would play out as a practical matter. What witnesses introduce evidence at the motion to suppress hearing? And
I think it's, I'm sorry, I think it's more than just as a practice. I think what Judge McMullen is asking for, and I know I'm thinking, is supplemental briefing on the actual issue of, is this a two-pronged test? And then, as in, does the defendant have to establish custody, and then we move into voluntariness? And then I think to Judge McMullen's point, how does that work as a practical matter?
I mean, I'm looking at it as being potentially abused by police officers. I mean, the entirety of our argument today has been, is this really just limited to domestic situations? But if we do adopt the majority view, this will be applied not just to domestic situations, it will be applied across the board. And so because neither of your briefs address this issue, I think it would behoove you to do so before we try to jump in and adopt it as a law.
And I see agreement from the defense that you would like to brief the issue as well. Then,
Presiding Judge Williams, can I ask you one more favor? Can we also ask them to supplement the record with the briefs that were filed with Judge Ward as well?
that was my second question to her.
Thank you.
And you still stand by, you would like to supplement the record with those briefs as well?
Yes, Your Honor, I do. I've actually read the briefs, those given and filed by the defense counsel, and I can tell you that they don't address this issue.
Oh.
Like, I can still supplement the record.
They still don't address the issue?
No, Your Honor,
He
not
specifically
the briefs.
asked it. He was explicit in his order. That's what I'm blown away. Okay.
I understand that. But
Okay, so we'll put down an order today or tomorrow, requiring the supplementation of the record with the briefs. I hope you and the state can agree which one's which and get those in pretty quick, because at least she'll have a chance to look at it before she files her supplement briefing. And then after she files her supplemental briefing, you will have 15 days to file yours. Does that sound okay?
Yes, Your Honor.
Okay, and you're pretty clear on what you think you need to provide for us. It sounds like to me you're going to help us out and some of the things both sides will be, and some of the things we're concerned about.
I think I am clear on that.
Very well. She still has rebuttal. Do you have anything else?
I had one final comment to make, and that is that on the question of harm analysis, and the final thing that defense counsel said was it's clear that his confession, based on his confession, the jury convicted only for, the lesser offenses. But it's not so clear because he never actually admitted to anything coercive. So it's not that just on, this is not a situation where he confessed to the whole crime. He gave a very vague and limited statements, and the jury's verdict can easily be looked at as more of a jury nullification kind of thing, where they gave him a break because of the circumstances of what outraged him. And not that it did not, their verdicts did not track his statements.
One of the things that our new protocols have done is we're not under the gun with people sitting behind you, ready just to jump in the seats like we have been for 20 years up here. And for that reason, we are able to give you a little more time to talk. I hope it's beneficial to you. I don't mind giving it. These are lives at stake, and they're citizens of Tennessee, or be affected very greatly, or could be, by what we decide. And it looks like to me granting you 2 or 3 additional minutes along the way will not harm our justice system in any shape, form, or fashion. And in fact, it might enhance it some. So thank you very much. But you do have your rebuttal time, whatever you need to take.
Okay, thank you, Your Honor. With regards to the two-pronged standard, the defendant having to initially prove that he's in custody for purposes of interrogation, you know, I've already made my argument regarding the first prong, and we would submit that it's clear that he was in custody. But as to whether there was a police interrogation, again, we would assert that I think one of you brought it up, it's totally unfair if there's a lack of record to ask him to recall exactly what the police had asked him while he was sitting in the back of the police car, likely, you know, at least a little bit.
Isn't that a factual determination to be made by the trial court? If there's no proof, the state that wouldn't have any proof either, or you cross-examine on the fact that it wasn't memorialized. Isn't that a question, a discretionary issue to be determined by the trial court?
Yes, Your Honor, I think it would be, but I mean, again, in this case, there's just, again, like a total lack of evidence. We know it would be unfair. There were 20 months that lapsed between, I think it was the motion to suppress and his arrest, or the hearing on the motion to suppress. And you know, even if you were up there testifying, it's kind of, I mean, I'm not sure how he's expected to recall that. With regards to Ms. Frisbee's unusual and particularized details about her alleged assault, I mean, we've already briefed this, but her story did change between the date of the assault and the date of trial. She testified at trial that Mr. Moran attempted to insert his flaccid penis, not attempted, but did manage to insert part of his flaccid penis inside of her on the date of trial. That was something that she never told the police officer at the scene, and that was something that she never told the rape crisis nurse. That was something that never came up until the date of trial. She also testified that Mr. Moran digitally penetrated her, which, as you know, would have amounted to rape, which he was not convicted of. She testified that Mr. Moran led her around by her wrists. There were no bruises on her wrists. There was no injury to her wrists that was observed by anyone that was involved. And there was just, I mean, we would assert that there was just a total lack of physical evidence that actually linked Mr. Moran to this crime. All of the evidence was totally circumstantial, and all of it was based on Ms. Frisbee's own statements. There was a roommate that was present in the condo or the townhouse at the time of the assault, and he testified at trial that he didn't hear anything, even though Ms. Frisbee testified that Mr. Moran was screaming at her the whole time. They were in close proximity to their neighbors because it was a townhouse, and the police didn't bother to interview any neighbors. No neighbors came forward. The police didn't bother to interview the roommate that was in the house at the time. We would just assert that there was a total lack of evidence. With regards to the discrepancies between Ms. Moran's, or excuse me, Ms. Frisbee's testimony and Mr. Seals's testimony, Ms. Frisbee did state that when Mr. Moran answered the door, he was screaming at Mr. Seals. Mr. Seals described him as being calm. Ms. Frisbee testified that Mr. Seals interrupted the assault, and Mr. Seals testified that, and then it took her a minute to get dressed and go downstairs. And Mr. Seals testified that when Mr. Moran opened the door, he saw Ms. Frisbee standing, behind Mr. Moran, packing a bag, getting ready to go. And we would submit that those are significant discrepancies, and we think that the jury picked up on that, and that's why they decided not to convict Mr. Moran of rape and kidnapping, which he was charged with. But so, for all of these reasons, we would submit that the court's decision to admit the confession was not harmless error, and we would respectfully ask this court to reverse the trial court's decision and remand for a new trial. Thank you.
It is indeed a pleasure to have two very qualified attorneys in front of us giving these arguments. Very well done on both sides. Thank you very much. We will stand.
Judge, could I just say one thing? Ms. Wiseman,
Yes, Your Honor.
I wanted to commend you on your brief. I don't know if I've seen you in the appellate courts before, but it was extremely well done. However, I would caution you when you are critical of the trial court, especially when the trial court drops an order this extensive and saying things like without citing legal authority. Just be careful when you do that. Again, I just want to applaud you as a young lawyer coming in here, giving us a brief this well done. I was very impressed, and I felt like I was very prepared for the issues this morning.
Thank you, Your Honor.
So now with that, we will stand in recess to 1:30. Is that right, Mr. Clerk? 1:30. Thank you.